terms, making good progress. So far, so good. So you'll have them back hopefully by the end of the month. I think I'll be done, and we'll do the review sections. Okay. Questions? Anything in your mind from before the break? Anything in your mind from before the break? No? Okay. Let's start then. Today's class begins a new direction for this course, right? We started off talking about the structural features of the Constitution, the Commerce Clause, Necessary and Proper Clause. Then we moved on to federalism, that is the division of the power between the states and the federal government. And then we moved on to the Reconstruction Amendments, the 13th, 14th, and 15th Amendments. But as we learned, in the early years after the Civil War, the court read those provisions very narrowly. That led to cases like Slaughterhouse, Plessy v. Ferguson, the civil rights cases. And in all these decisions, the court basically didn't give much weight to these new amendments. Starting today, we're doing a new topic where the court expands the scope of the Reconstruction Amendments. And specifically, they expand how they read the Due Process Clause of the 14th Amendment. And there's something of a paradox, which you'll realize very soon. Where the 14th Amendment should apply the greatest with respect to racial equality cases, you've got Plessy and you've got civil rights cases. They read it narrowly. And where you think the 14th Amendment might not be so important, case involving bakers and minimum wage laws, they tend to read it broadly. So how can it be that an amendment ratified in the wake of a bloody civil war isn't being used to protect the beneficiaries of that amendment, but it is being used to protect economic rights and the like? This keys you into a very important fact of constitutional law. It's not a straight line, right? ConLaw doesn't go in a straight line or even a straight line going up. If you remember your high school math, it's kind of like a sine wave where it ebbs and flows, goes ups and downs. And at various points, the courts read these provisions broadly or narrowly. And even within certain eras, the so-called progressive era, the court is not consistent. You have a case like Lochner in 1905, which rules in favor of the liberty of contract. And then a couple years later, you have Muller v. Oregon, which rules against the claim of economic liberty. It's always tough to try and draw a straight line reconciling all the cases, and I don't think you should try to. It's not very useful. But you need to know the narrative of how these cases flow. So our class today, on Thursday, and next week, focus on how the courts have looked at the word liberty in the 14th Amendment's Due Process Clause, right? All right, is there any question on that? All right, I didn't ask you your question yet, but I'm going to ask it to you in a minute. But I want to first give you a story. Has anyone ever read the story The Lottery? It's a short story. A couple of you? All right. Well, don't give away the ending. So let me just sign it one year now. You guys don't like to read stories, right? Let me briefly describe it for you. It'll be easier than actually to read it. So the story begins in a small town of a few hundred people. And it's June 27th. And everyone's getting very excited for the harvest coming up. And right before the harvest, there's something called the lottery. Okay? So on the night before, June 27th, everyone starts gathering together in the town. And they take a safe, right? A safe, and they put in these little slips of paper, right? One slip of paper for every family in town. And one of these slips of paper has a little black mark on it. Okay? So the next day, everyone goes to the safe, and every family, head of the family, draws one slip of paper. Okay? And one family, the Hutchinsons, they draw the slip with this little black mark on it. So then they have another competition. Each member of the family, the Hutchinson family, draws a slip of paper from this safe. And it turns out that Bill's wife, Tessie, draws the slip of paper with the black mark on it. Okay. At that point, as is tradition, everyone starts gathering rocks and they stone Tessie to death. You didn't see that coming, did you? And as the rocks are flying at her, she's saying, "It isn't fair. It isn't right." So my question for you, and there's not a right or wrong answer here. Believe me, I want to see where the class is as a poll. The lottery is fair. Is that a true or false statement? Again, there's no right or wrong answer to this question, but I do want to see where all of you are. All right, go for it. See what you guys. This will be 30 seconds. Okay. Again, there's not a right or wrong answer here, but we'll, I think, draw from you certain principles. All right, let's stop here. Does anyone remember where I left off before the break? I have no idea. Are you, Stephen, are you next? Wow, good memory. Okay. Stephen, what's your thinking here? Is this fair?
I mean, I don't understand. Like, why did they draw again?
I gave you all the facts I'm going to give you. That's it. I'm not giving you any more facts, not evidence, my friend. That's all you're getting.
I mean, it's just one of those, like, luck of the draw. Like,
Well, so Stephen, let me try it this different way. How would you go about deciding if this is fair? This regime, this lottery.
I mean, they're like that's what I was saying. Like they're deciding as far as like luck of the draw instead of like an actual decision.
That you keep saying luck of the draw. Yeah. My question to you is: it fair? I mean, it's certainly. Well, let me ask you, Stephen, this question: is there any allegation that the paper was rigged? That something was done to make it that Tessie would take the black slip and no one else, or is it completely neutral? So why is that not fair?
I mean, it's just life. If she was stoned to death, I mean, it's one of those that you don't want to put your life on.
Oh, okay. Ambrose, what do you think, my friend? Is this fair? You have to explain why afterwards. But what's your thinking here?
I put true. That is fair.
Okay, tell me why you think that.
Because everyone just draws. It's an equal draw.
Everyone's an equal shot at getting stoned.
Yeah, I mean, it's not like one paper. It's not like one person like you gotta pick this paper. That one has the black dot on it. So if they know that you're gonna get stoned, they kind of just everyone puts their hand in the pot and everyone just gets.
Oh man, Judge, what do you think?
Well, I put false when I think you did think true. I think there was a fairness that everyone agreed to this lottery if they did because they're participating in it. But I put false because I just think as a whole system, it's not fair to arbitrarily kind of just kill someone off the lottery. But
Well, no, but you said is it arbitrary though?
In a sense, yeah.
How is but didn't we just say a minute ago that it's completely random whoever draws the paper? Is it arbitrary? What does arbitrary mean, Judge? You used the word, big word, right? What does that word mean?
With no basis of like.
So Judge, is your problem about whether it was actual random draw from the pot, or is your problem that the entire lottery itself thing is unfair, the entire system?
I think the pulling of the pot, say if like they needed population control or something, and as messed up as that is, they actually have a reason saying to kill the oldest person in town or something like that.
Okay, so you're saying that the entire notion of sacrificing a person to sustain a good harvest is irrational, that it makes no sense. All right, Herberto, now I'm going to change the facts a bit, okay? We're going to do it for Steve, I'll do it for you. Let's say that there's a vote on this every year, right? And the people say, do we vote to keep the lottery? And people say, you know what? Every year we've had a good harvest for 30 years straight. Let's just stick to what we know, right? Let's do what we're familiar with. Let's keep this tradition going because we know it'll keep us hungry. Because you know what? If we don't do the lottery this year, maybe we have bad harvest and we'll starve, right? Does that change your mind, Herbieta? Does that change your opinion?
The process is fair, but it's an outside question of is it right to kill somebody for whatever reason? But the process itself, what they're doing, that's fair. It can be because it tries to pick out anybody without discriminating for race.
Yeah, it doesn't. It's totally fair. Men, women, children, everyone's game. Now, Herbieta, let me ask you a follow-up. Tell me, my friend, what does the word fair mean? This is a word which you guys use in law school in every single class. And I doubt you've ever actually thought about it, right? If you ever see like a little kid, like, that's not fair. We use this word at every age of our lives. So I might use this word fair, right? What does this word mean?
Fair means
Oh, man.
something that, a close definition of fair would be something that everybody has almost equal chances to win.
So yours, it's a numerical fairness, right? If there's no bias, there's no putting your thumb on the scale, right? Everyone gets the same shot. Kelly, you're nodding. How would you define fair, Kelly?
Similar, I'd say equal share or burden or tit for tat type thing.
Tit for tat. Now, Kelly, does your understanding of fairness consider the fact that they're basically killing women because she drew a number of a hat, right? Does that we can all agree this is insane, right? I think this is nuts. Does that the fact that this is absolutely nuts factor into your definition of fairness?
No, because she consented to it.
Did she consent to it? Did I say she consented to it?
Yeah.
Well, but I'm going to go.
Majority of the people, I guess.
But I said the people voted for it. Did I say that she voted for it? Maybe she did vote it. Maybe she didn't vote it. Let me see where the class is right here. I think we got a good. Wow, wow! Look at that. Almost right down the middle. That's closer than in years past. In years past, it's usually false goes much higher. Wow. Okay, you guys are actually pretty evenly divided on this one. I see a couple hands. Abdul and then Jonathan.
So
And then Gabriel?
I feel like most of the definitions were defining equality. And when I think of fair, I think of justice. No,
Justice.
But justice and equality are definitely not the same thing. I feel like a lot of times they're conflated.
What's justice, my friend?
If you fed your dog and cat the exact same food, that's equality, but it's not justice.
It's not fair to the cat.
It's not fair to more to the dog. And it might even be different quantity, not just right? You might give a little bit to the cat, more to the dog. That's definitely not equality.
So when you say, let me just stick in a second, I'll get you guys in a minute. When you say, Abdul, when you say justice, do you mean like whether the law itself is just? Is that like what you're getting at?
I mean, this was abstract. I was saying justice.
No, but use a good word. I like the word justice.
I mean, I didn't have a concept.
All right, Jonathan and Gabriel, please.
So isn't it a social contract and acceptance by her part is performance? That she didn't have to do it at all. And
She
then on
could have
top of
skipped
that-
town and ran away. She didn't have to draw the paper.
Yeah, and then it's public policy. They all agree to it. This is what's good for us. So when it comes to fairness, it's based off of, well, what that.
What if I told you to use the fact today that women weren't able to vote in that town?
She could still run away. She's not adhering to this.
Okay, Gabriel, what do you think?
I just think the process is fair because it's, everybody has an equal chance.
Yeah.
However, because let's say they voted for it, the law has to make sense to what we're
The
doing.
law has to make sense. Okay, so that's a good point, man. What's that mean? The law has to make sense. What does that mean?
Well, he means that they cannot just like make this random law where, let's say in this scenario, one of them picks the lottery and, they're gonna get stoned to death. Even though that's the law that they all voted, it has to make sense.
Well, it makes sense to them, Gabriel. They voted for it,
Yeah,
doesn't it?
but not even just makes sense to them, but like even to the national level.
Oh, okay. So Gabriel raises a fair point, right? He's like, look, even if they're crazy and they voted for this idiotic law, right? Does it make sense to third parties, right? Objective people. And this is where I'm heading with this. I'll get you guys to, I promise. Can courts step in, decide, you know what? This law doesn't make any sense. This law is insane, right? I know you guys voted for it, but you guys are nuts, right? Can courts step in and substitute its judgment for the judgment of the voters? This is what Gabriel's saying. Like, look, even if these insane people voted for it, look, national level, if we want to call it someone else, say these guys are crazy. Can this right of democracy, self-determination, be trumped by some third party. Let's call them judges. And this is the basis of the rest of the semester, pretty much, right? You have a provision of the Constitution. And it's very simple. It's only a few words. It says, nor shall any state deprive any person of life, liberty, or property without due process of law. And there are two ways of reading this provision, right? The book, I think, summarizes it, right? One approach focuses on the word process. That is, you can deprive someone of their life, liberty, or property so long as they're given the process that is due. That's what due process means. This phrase goes back all the way to Magna Carta in 1215, this famous document in English barons, right? The government can take away your property, your liberty, or your life. That is, they can execute you, your life. They can take away your property, your stuff, or your liberty. They can imprison you, so long as you're afforded the process that you're due. Is that a trial before a judge? Is that a trial before a jury? Is that a hearing? Is that the right to challenge your accuser and confront your accuser? Is that the right to cross-examine a witness, right? Whatever that process is, that process must be accorded. That is what we call today procedural due process, right? Procedural due process. This is a phrase that didn't exist till 20th century. It's a fairly recent phrase. But this is what's known as procedural due process. If the government wants to fire you from a job, can they just fire you randomly? Or do they have to give you a hearing first to explain why? Okay? Procedural due process. But there's a second way of reading this provision, right? Instead of focusing on so much on the process that's due, you can do what Gabriel said, right? Is this law itself just? Justice, Abdul's word, right? Is the rule itself make sense? This is Gabriel's word, right? Does it make sense? Is this a just law? That is, when a law is depriving you of your liberty, in this case actually your life, just getting stoned to death, can the courts assess whether that law is fair, just, makes sense, arbitrary? These are words all of you threw out. I didn't have to prompt you, right? You came to these words yourself. Arbitrary, just, unfair. Does it make sense? These are words you guys use, which are all good words. Okay? And if a court decides this law is unjust or unfair or it makes no sense, no amount of process will save it, right? It doesn't matter if we change the facts a little bit. And before she was executed, she had a hearing. And they said, did you draw the paper? Yes. Okay, now we'll stone you to death, right? A jury has to decide, did she draw the paper with the little mark on it, right? Okay? If the law doesn't make sense, if it's an arbitrary deprivation of liberty, if it's an unjust deprivation of liberty, no amount of process will save it. That's the important point, right? It doesn't matter what process you're given, because it's such an arbitrary, unjust, nonsensical deprivation of a liberty interest, right? This is what has come to be known as substantive due process. What does this word substantive mean? Think of it this way, right? Think of it this way. We have to take the word liberty in the due process clause. What does the word liberty mean? Okay? What does the word liberty mean? Well, we can give an easy example, right? Life. We know in the lottery that her life is being taken. She's literally being stoned to death. That's easy. But what if instead of we're talking about life, we're talking about liberty? What is the meaning of the word liberty? What is the substance, right, of the word liberty? Does it include free speech, the right to bear arms, things in the Bill of Rights? Does liberty include the right of contract? Does it include the right to purchase property? to buy a house on a block of people of different skin color than you are, right? What does this word liberty mean? And so the challenge for the courts is twofold, right? What exactly is liberty? And is a law depriving you of that liberty a just law? Is it a fair law? Is it an arbitrary law? Right? So under this branch known as substantive due process, courts have to judge whether the law itself makes sense, not whether you've been given adequate process. Right? She drew the paper of the thing, but there's no doubt about it. But whether the law itself is just, is it arbitrary? And what I suspect is of the people in this classroom who voted false, I'm guessing almost all of you said this law was completely arbitrary, it doesn't make sense, it's insane, right? You guys were doing substantive due process. And then the other half of the class, right in the middle, like, look, she drew the paper. She got her fair hearing, right? It was completely fair. There was no rigging. Everyone had an equally likely shot of drawing the paper. Actually, remember your statistics with probability. When you don't have substitution, it's not as random. Every subsequent person has a more likely chance of, but it's not important for here, right? So I think the first half of you guys, the 40s, did someone just change your vote? Someone just changed your vote. That's fine. I'm okay with that. That's fine. It just got a little bit closer. Look at that. Good. That's why I left it open deliberately, right? So really, right down the middle, 36-39. So about half of you look, I think, at the due process clause in the first way, that it's about procedural fairness, that she was given the same chance as anyone else to pull the paper. And then the second half of you guys said, this is, I think another person changed your vote also. Oh, someone voted E. Give me a break. Okay, stop. Stop. No, now you're messing it up. There's no E. That's not an option. That's not an option. Okay. Wow, right. I think someone changed it again. But this is an unfair law. As you make your way through this topic, I want you to keep in mind this notion of procedural due process versus substantive due process, right? The lottery. This is an easy case, right? A woman's being stoned to death to get a good harvest. I think everyone can say that's nuts. But that's not the way you guys voted. You voted based on what does the law require? Can courts come in and second guess this execution? Right? We'll get to much harder cases involving minimum wage laws, hour laws, abortion laws, right? All of these cases stem from the same notion. Can a court come in and second guess the decisions of the legislature? Just to make a very easy example. In the Lochner case, we'll discuss in a couple minutes, one of the laws at issue was a law that said ceilings have to be a certain number of feet, right? You have very tall ceilings that provide for proper ventilation. The court upheld that law. They said it has to do with health and safety, it's fine. In about a month, we'll do another case involving abortion, right? Texas, your state, has passed a law saying hallways have to be a certain width, right? Hallways have to be a certain width. That way stretchers can make their way through the hallways in case of an emergency, right? There's a medical emergency. The Supreme Court struck down the law saying hallways can't be too wide. Just think about that for a minute. Let that simmer for a few weeks. Sorry, want to raise your hand, please? Yeah. Holman's Health versus Hellerstedt. The court struck down a law about the minimum width of hallways in certain clinics. Let that simmer for a bit. Yeah. Okay, I didn't call on a lot of people before, but you're welcome to chime back, and I forgot who I was. So, Kevin?
So is it fair to say procedural due process is more about opportunity and substantive due process is more about outcome?
I don't know what that means.
So
you want to try to give an example?
So I guess like procedural, you have the opportunity to present your case, and substantive and like the outcome of what happens after the, I guess, you're given your due process.
Okay. I don't think it makes a difference, right? Because Kevin, let me answer your question this way, right? Let's say that this took place in Houston, right, where you had a town that did this thing. Let's say immediately before they start stoning her, the wife goes to federal court and asks for an injunction, and she says first that this procedure was absolutely unfair, and second that the law itself is unfair. Okay? The court could probably stop on either ground. They could say that drawing a number of a hat is completely random. It's not consistent with the due process of law. That that in order for you to deprive someone of their liberty, you need something a little bit more substantive, the reason why you're killing her. Or the court could say, this lottery is freaking nuts, we're going to just stop it altogether. So both of them would affect the outcome. In either case, she would still be alive, I think, right? But I think Kevin's question is really close. Wow. I've never had that close before. I think Kevin's question highlights the fact that they wind up in the same spot, right? If your life or liberty can be taken away, how do the courts get there? And very often, either approach will probably lead to the same direction. If you have completely random law, it's probably arbitrarily depriving of your liberty. And if it's being numbers out of a hat. Now, the better question is, what if there was a jury trial, right? Where a jury had to determine if this person should be killed so we'd have a good harvest. And unanimously the jury said, you know what? We've decided as members of the jury that if we want to have a good harvest, Tessie's the one who's got to get killed. And there was a jury trial, evidence, rules of procedure, everything was followed, right? At that point, I think the procedural due process claim falls apart. But the substantive due process claim probably sticks. Now, I want to mention this because these are not non-controversial, right? The notion of substantive due process is very controversial. First off, the name itself, Justice Scalia called it an oxymoron, like Back to the Future or Jumbo Shrimp, right? It's inherently a contradiction. How can you have something procedural that's substantive? Aren't those the opposite of each other? But more pressingly, the reason why substantive due process is so controversial is that there's not much guidance, right? It just says you can't be deprived of liberty without due process of law. What does liberty mean? The doctrine of substantive due process lets judges, who are not elected, decide the meaning of the word liberty without many guideposts, right? Without any ways to help them out. Abraham Lincoln famously has said this one quote. He said, "We all declare for liberty," right? Who doesn't love liberty? But in using the same word, we do not mean the same thing, right? And he gives this great example. Okay? The shepherd drives the wolf from the sheep's throat, the shepherd drives the wolf from the sheep's throat, for which the sheep thanks the shepherd as his liberator, right? So if you're a sheep and your shepherd saves you from a wolf, oh my God, my shepherd, the Lord's my shepherd, right? The shepherd is my liberator. But from the wolf's perspective, and Trey laughed at that one, but from the wolf's perspective, the shepherd is destroying his liberty. So it all depends where you're sitting or standing, right? If you're the wolf or you're the sheep. The exact same act can look differently to you. So because there's such a differing opinion about what liberty is, it's dangerous perhaps to let judges decide, number one, what liberty is, and number two, invalidate enacted laws that pass through the democratic process because they thought it didn't make sense. Now, a few minutes ago, Gabe said, if you look at the national level, right, this is nuts. The judges take polls, right? They do surveys to see what's trending on Twitter to decide what the law is, right? I mean, Twitter is now law apparently, right? But how are judges supposed to know what liberty is? Okay? So there's some easy definitions of what liberty is. Damon, yes, sir.
So we had the Fifth Amendment that was talking about the just compensation, and then we had in due process clause, due process of law. So it's like the reason that the 14th Amendment due process clause came in to move from the substantive due process towards more of procedural due process.
Okay, well, thank you. So first, Damon makes a fair point, which I was going to mention later. I'll do now. There are two due process clauses in our Constitution, right? There's a due process clause in the Fifth Amendment. That controls federal action, right? That means that the federal government cannot deprive you of your life, liberty, or property without affording you the due process of law. But there's also a 14th Amendment due process clause. And this prohibits the states from depriving you of life, liberty, or property. Okay? Now, Damon asks, is the shift from the 5th to the 14th about moving perhaps from substantive to procedural due process? Let me answer your question this way, Damon. Before the 1860s or 50s, there wasn't much discussion of substantive due process under the federal Constitution. There was one very important decision in which the Supreme Court recognized a substantive liberty interest in the Fifth Amendment. Do you know what the issue I'm talking about? No. A very important decision from the 1850s. Thank you. Is that it? Kenny, yeah, say again? Dred Scott. Remember what Tawney held, right? That he said that owning a slave is a liberty interest for the master. And the Fifth Amendment says you can't deprive them of that right. But again, let's do wolf and sheep, right? To the master, the ownership of a slave was a liberty interest. To the slave, it was a form of oppression. So the exact same liberty interest has two sides of the coin, right? You see that? But in the late 1880s, and this is my transition to our cases for today, the court began looking to the due process clause to protect not only rights of procedure, but also rights of substance. And this was in no small part due to what happened in the earlier years of the 1800s. Slaughterhouse cases, right? Does the privileges or immunities clause protect the right of contract? I think it does, but the court said it doesn't. Okay, so they moved on from privileges or immunities down to the next line. They said, okay, if PRI doesn't protect the right of contract, as it said in dissent, we'll say that the due process clause, right, that a liberty interest in the 14th Amendment includes the right of contract. Everyone with me so far, right? Everyone with me? Okay? This is an important point. Because of Slaughterhouse, the court moved to another provision where it makes less sense. To say that a privilege includes the right of contract as a linguistic matter makes sense. But to say that a phrase about due process requires you to have contract, it's a harder fit. In any event, the court moved there. And in a series of decisions in the 1870s, 1880s, and 1890s, the court began to suggest that one of the liberty interests protected by the 14th Amendment was a right of contract. And this wasn't made up of whole cloth. We've talked about this before. The Civil Rights Act of 1866, this was what most people think is the precursor to the 14th Amendment, says you have a right, regardless of your race, to inherit, purchase, lease, sell real and personal property. Okay? Go forward a couple of years. You have the Civil Rights Act of 1870, which says you have the right to make and enforce contracts. Is it really so insane to think that the people who drafted the 14th Amendment would have understood contracts and property as among the liberty interests being protected? Is that really so crazy? Some people say it is on the other side, but it's at least there's some historical basis for these rights. In fact, did anyone see my thing on C-SPAN, the ICWO thing? Yeah. I tried making this point on the air, if you slough through 90 minutes of it, that the case was in large part about contracts, right? They didn't rule for Mr. Lee Yick because of any Chinese discrimination. They did it because it was a property interest. And if you understand Yick Wo in this line, Lochner and other cases, it makes a little bit more sense. Because you can't go from Yick Wo to Plessy in a couple of years like, wow, separate but equal, evil eye, unequal hand. But this is, I think, a good starting point. All right, so any questions before we get started with the first case? A lot of you have your hands up. Sorry if I jumped over you. I had to move a little bit. Anyone? Oh, yeah, Stephanie, go ahead, please.
When I started reading, I was thinking about Gibbons. Was that more? That was a contract too, right?
Well, Gibbons v. Ogden involved the Commerce Clause, right, of whether the state had the power to grant a monopoly to one of the steamships, right? But are you asking about whether the states can violate someone's contract? Is that what you're asking?
Yes.
Aha. Well, yesterday at the Supreme Court, there was a case involving the Contracts Clause. A clause, which, did I even mention the contracts clause? Oh, I haven't mentioned. Okay, now I will. Thank you, Stephanie. You gave me an excuse. Okay, go to Article 1, Section 10. I have a different constitution than you do. Just take it out. And just someone just shout out a page number. Article 1, Section 10, please.
39.
Thank you. Page 39. In the first paragraph, it lists all the various things that states cannot do. Okay, and it says at the end, no state shall make a law impairing the obligation of contracts. Everyone see that? Right? It says no state shall make a law impairing the obligation of contracts. Okay? So Stephanie, there's a provision that's much closer to this. In the 1800s, I'm not joking with you, this was probably one of the top 5 most important provisions of the Constitution. Almost every major litigation before the 14th Amendment involved this provision. There was, in fact, a case argued in the Supreme Court yesterday about this exact clause, right? States can't make a law impairing the obligation of contracts. The origin of this law was to prevent debtor relief laws. What does that mean? If a lot of people were under debt, the state would just enact a law saying, okay, we're going to wipe out all the debt. The people love that law, right? Imagine someone just wiped out your student loans. That'd be awesome. The creditors, though, not so happy with it. So as a result, what happened? They can't impair the obligation of contracts. Unfortunately, starting in the 1930s, the Supreme Court basically read this clause out of the Constitution, as with many things in the New Deal. They said, well, in a time of economic crisis, the court can impair contracts, whatever. So, Stephanie, you're exactly right. You're on the right point, but this clause doesn't play any meaningful role in constitutional law today. But yeah, there's an express provision that states cannot impair the obligation of contracts. Okay, but thank you for the question. That's not what you expected, but I gave it to you. other questions? Oh my God, when I was on TV, I screwed up. So I had my microphone on here, and I went to reach my Constitution, I knocked my mic off. It was bad, but I figured I was able to reconnect it. But it's a hazardous occupation, taking out a Constitution on live TV. Very, very, very dangerous. People are nuts, though. Those callers are crazy. I don't know if anyone were listening towards the end. They people, whew. C-SPAN, they take everything. God bless them, but you gotta just. Thank you, caller. Yes, that's right, hand from here. Yeah, Cameron.
When it comes to viewing things from a substantive due process, how do the courts take into account, for instance, the farther up you go in the appeal statute from the federal side, the farther away you come from a state that you, a rule to them might make sense for whatever reason because of them, but the farther away you get, the crazier it is. Because there are rules that apply differently to different communities.
Oh, what a good question. All right, let me answer this in a couple different ways, right? And let's just use contemporary stuff, right? Texas is a fairly conservative state, as a matter of course. California is a fairly liberal state. If you took a poll of what's fair in Texas and what's fair in California, I think you get completely opposite results. And that's not good or bad. People are different, right? Different opinions. But when courts employ substantive due process at the Supreme Court, it forces a single standard nationwide of what might be fair or not. And there are pluses and minuses to that, right? I could ask the question differently. If you took a poll on segregation in the 1950s, and let's say you took one poll in Texas, and you took another poll in Maine, you get very different results. And so you might like it when the Supreme Court sets a single standard for, say, interracial marriage, right, in the 1960s. But you might not like it setting a single standard for, say, abortion in the 2020s. So there are pluses and minuses to give courts the power to set a single uniform standard nationwide. But as a general matter, constitutional rights don't vary by state, right? If you get pulled over in New York, Texas, or California, the Fourth Amendment should apply in the same fashion, right? The traffic stop rule shouldn't vary by states, right? There are some exceptions to that, but that's generally the rule that your rights don't vary by state, nor should they. but substantive due process forces that. Any other questions to get started? So let's go to the first case. This is a case that's not usually assigned in case books, but it's fairly significant. As the court began to consider whether the provisions of the Bill of Rights extend to the states. Now, I had you all read, I think the first or second week of class, Barron v. City of Baltimore, right? Who am I up to? I think, Elena, you next? Do you remember what was the holding in Barron? Barron v. City of Baltimore. Exactly, thank you, right? This was an opinion from Chief Justice Marshall. And the opinion said that the takings clause of the Fifth Amendment does not apply to the states. That is, the states are free to seize property without providing just compensation. To state it a little bit differently, if a citizen of Baltimore doesn't like that rule, he can go amend his own constitution, right? Go amend his state constitution and ensure that compensation is provided. Okay, that was Barron. But then we had the 14th Amendment. And then the question changed, right? Were the states now controlled by the Bill of Rights? Well, we did a couple cases, right? Cruikshank asked whether the Second Amendment now controls state action, right? Can the state governments now infringe the right to bear arms? Cruikshank, remember the case of the Colfax massacre? Those people got burned in the church, right? Awful case, right? The ruling was even worse, because the ruling said that the Bill of Rights does not control the states. That despite having this bloody civil war and this recognition that the states were violating people's rights left and right, that Cruikshank said nothing changed. Cruikshank said Barron is still the rule of the law, the law of the land. Okay. But Cruikshank was brought under the Privileges or Immunities Clause of the 14th Amendment, right? Cruikshank was brought under Privileges or Immunities. So we come now to the next case, Chicago, Burlington, and Quincy Railroad versus City of Chicago, which looks at a different provision, right? Can a state take private property without just compensation? Or to state it differently, would taking private property without just compensation deprive someone of property without due process of law? Let me say it one more way. Does the due process of law require compensation to be paid for the taking of property? Now notice, I did not say, does the Fifth Amendment's taking clause apply to the states? This is a very common misconception, right? If you ask probably 10 law professors, half of them will get this wrong. Trust me on this one. Harlan's opinion does not mention the takings clause, not even once. Doesn't mention it. It's not there, right? Instead, Harlan's opinion discusses whether the due process of law, these principles of fairness, can require the payment of compensation when property is seized, right? So I want to understand what this case does and does not say. Decades later, the court will cite it for saying something else it never said. All right, so Bianca, you want to give us the facts here? They're pretty straightforward.
So there was an ordinance in the city of Chicago that required the streets to be open and widened, and so certain parcels of land owned by several individuals, one of them being the Worley company, had to be taken in order to widen and open the road. The plaintiffs filed a petition which asked for compensation for the land being taken. The jury awarded the plaintiffs $40, and the Worley company petition the award, the appeal and the jury trial, and the grounds for the trial is that the statute and judgment were contrary to the 14th, declaring that the state was depriving them of liability and property without due process.
Very good. Thank you, Bianca. Okay, so what we have here is a case involving the railroads. And it's hard for you to understand today how important the railroads were, right? The same way you think of like Facebook or Twitter or Google, that was the railroads, right? This was like the big industry in the United States because it allowed for communication across the continent in ways that just could never be done before. And one of the ways that railroads exist is by existing as what's called common carriers. You say this in torts and contracts, probably. The idea of a common carrier is it's a quasi-monopoly, right? It's a quasi-monopoly. That is, the government allows them to have access to public land to build the tracks, right? You got to build the tracks somewhere. And in exchange, the railroads are required to be open to all customers on equal pricing. They can't turn away customers. You have plessy and separate but equal, but that's a different story, right? But in theory, at least, they have to be open to all customers. But with that, the trains get the power of eminent domain. You'll learn about eminent domain and property too. And this is the power of the government to take private property for public use. A train is public use. A pipeline is public use. These sorts of things are pretty well settled. But what was unique about this statute is it fixed the compensation at $1. It fixed it at $1, right? The Constitution says the compensation must be just, right? This is Abdul's word earlier. The compensation must be just, right? Usually a jury would decide what just compensation was. But here it was the statute that decided it. So the question is, was this law in compliance with the requirement to give due process of law? Was fixing the compensation at a single dollar giving the railroad the process that they were due? Right? Min, what was the holding then? What did the court do here? I'm sorry?
The holding, they say that needs to be compensation, but they didn't mention anything about that law.
Okay, right. So the bottom line, Min, is correct. They basically punted, right? I'll get to all this stuff in the middle. But the bottom line said, well, we're not in a position to decide if $1 is fair or not. And they actually affirmed the lower court. So the entire opinion is very bizarre. So this is why people usually don't assign it, right? The bottom line of the case is they held the $1 was adequate compensation. Justice Brewer wrote a dissent to this. He's like, what are you guys doing, right? You give this really powerful opinion, and then you kind of just, pet her off, right, as if it's nothing, right? So that's the holding. That's easy, right, that a $1 compensation was just. But far more important is what comes in between that, right? So, Fernando, how does the court assess whether the taking of this property complied with due process of law? What's the court's analysis here? Justice Harlan talks about a lot of things. He goes through a lot of different items. What does he say? Well, Fernando, let me ask the question like this. Why does Justice Harlan think that compensation is required under the 14th Amendment? What tells him that? What tells Justice Harlan that compensation needs to be paid for it to be complying with the 14th Amendment, Fernando? Kenny?
Well, you kind of just talked about kind of just general principles about you have the universal right to not have your property taken away from you, and such cases and some legal philosophy.
Yeah. Let's see, is that name tag? Sorry. Good, Andrew. What? Kenny made a point. He's finding like general principles, legal philosophy. What exactly is he getting here? What are these various things he's citing? What are these things he's citing here? how does he fill this substance? Where does he get it from? That's my question. Sam?
Well, I assume that the cases he was talking about were like an application of the Fifth Amendment due process clause have been before this and when they've been applied to the states.
But didn't you also cite state court decisions?
Yeah.
What's the relevance of those decisions? Why would he cite state court decisions from before the 14th Amendment was ratified? Why is that relevant? Why is it relevant that he's citing state court decisions from before the 14th Amendment was ratified? Why is that relevant? He cites a bunch of them. New York, New Jersey.
I just think, I guess you would need some kind of background for where he's trying to go.
Oh, we're getting close. We're getting close. Cindy, why is he citing all these state court decisions, these various treatises? Why is he citing these various things? What relevance do these things have? That's right. That's a conclusion he's trying to draw. But why is he citing these things? Why are these things relevant? He doesn't cite the takings clause. He's citing state court decisions. Why is he citing state court decisions about the importance of compensation, Cindy? That's the question, right? Why is he doing this? Why? Anakari, you want to take a stab? Why is he citing all these, page after page? They're in the book for a reason, right? Why do you have to read this? Why make you read this?
I guess to show that somehow the 14th and the Fifth Amendment are kind of the same.
What do you mean? I think you're close.
They're connected, and the Fifth Amendment, he doesn't mention the Fifth Amendment, but if you think about it, by stating the cases, he kind of does.
Oh, okay, now we're close. Okay. Benny?
Bottom of 902, after he cites all these state cases, etc., he says, he's referring to the Chancellor of New York. It was a principle of national equality recognized by all temperate and civilized governments from the deep universal sense of justice that fair compensation be made by the owner. And earlier before, he talks about limitations on government.
Very good. So everyone heard what Denny said, right? Do you like the fair, what was that quote, the fair what? Fair representation?
National equality recognized by all temperate and civilized governments.
Okay. What Harlan's basically saying here is that all civilized governments must provide compensation. That as a matter of history and tradition, any reasonable government will compensate for the taking of property. His argument is this: the Fifth Amendment's irrelevant to this case. It doesn't matter whether Congress in particular has this imposition, because all governments must have this requirement. Let me say this a little bit differently. That the due process of law, that the process that is due, relies on this general understanding that if every civilized government provides compensation, that is the process that's due, right? In other words, to determine what process is due, we look to the history of what various governments do. And if there's a consensus that all governments have the same requirement, then that process is due. Otherwise, it's an arbitrary deprivation of property. Look at what Harlan's saying. He's not saying the Fifth Amendment applies to the states, to the 14th Amendment. He's not saying that at all. What he's saying is that all governments that are bound by the due process of law must provide compensation. Everyone see that, right? So the basis of this ruling is not what came to be known as incorporation, that the Bill of Rights is incorporated through the 14th Amendment. What he's saying is that this compensation requirement is so fundamental, so basic, that any government that deprives you of it is not complying with the due process of law. That's what he's saying here. It's a very important holding that most people miss. Okay? Hey, Brian. It's cited for that, but that's not what he says. Not yet. Right, so Brian mentions this phrase incorporation doctrine, which we'll get to later this term. But this is a notion that the provisions of the Bill of Rights are incorporated or extended, right? The idea is, what's liberty? Liberty includes the first 8 amendments of the Bill of Rights. Therefore, states can't deprive you of those. It's incorporating or extending the Bill of Rights is the word liberty. Many courts cite Harlan's opinion as the first incorporation doctrine, but there's no mention of it. There's no mention of the Fifth Amendment at all. That's not what Harlan was saying. Right? Harlan had a very broad view of what rights are required. Now, I'll mention this very briefly. In Barron itself, Barron didn't get paid for his taking. Right? He was not given compensation by the state. He wasn't. So do all civilized governments do this? Most of them do, perhaps. That's enough for Harlan. But then at the very end, he comes and he says, well, just kidding, right? $1 is probably enough. It's not for us to say otherwise. So I think what Harlan was trying to do here was establish a precedent that the compensation clause requires or applies, where you have to pay compensation, but he didn't want to intervene of what those adequate compensations were. As a general matter, courts generally don't challenge awards of compensation. They generally don't. All right. So any other questions on the first case, right? It's a strange opinion because it goes through all these things about compensation is so important. It says, oh yeah, $1 is fine, whatever. It doesn't really matter. But this was how, at least in the 1880s or 1890s, how the court considered the impact of the 14th Amendment.
So now that we said that this $1 is enough, then where is this just or fairness?
That's what Brewer says, right? That's Justice Brewer's dissent. I think you have a fair point, Damon. Yeah. That's what I'm saying. It's basically a punt, right? They go like he goes up to the finish line and it doesn't take a step over. He stops at the 1 yard line. Yeah, what?
Would it be fair to say that he bases his rationale only on whether procedural due process has been satisfied and doesn't consider whether the substantive rights of the were satisfied?
I'm sorry, say it one more time.
So to me, it seemed like he only cared whether compensation was given, and he didn't care whether it was nominal or not. So the dollar was fine because the state governments enacted it, and it went through the courts, and that's what they decided. So it procedurally was proper.
I think actually this is more of a substantive case, right? Because he had a trial, everything was fine with the trial, but the jury was not allowed to set the compensation, right? In other words, usually in a eminent domain proceeding, the jury decides what the compensation is. Here it was fixed, so they weren't challenging the procedure of how the trial proceeded, but the substance of the law itself, whether it was a fair law to set the compensation only $1. Is there another hand somewhere? Nothing? Okay. All right, let's go on to the next case. Lochner versus the people of the state of New York. By the way, most case books it just says Lochner versus New York. What I said up there. This was a criminal law case, and he was facing jail time. So they say the people of New York. That's because it's a criminal law matter. Okay, important fact. As was Muller v. Oregon as well. This is one of the most infamous cases in the Supreme Court's history. Many scholars rank Lochner alongside Dred Scott, Plessy versus Ferguson, and Korematsu as part of the so-called anti-canon. Now, if you're sitting here asking, wait a minute, Blackman, how is that possible, right? You have a case that deprived people of their humanity, locked them up in internment camps, segregated train cars. How can that possibly be on the same level as telling a baker how many hours a week he can work? Voluntarily. No one's forcing him to work. What's not slavery? He wanted to work that many hours. If you were in probably 95% of constitutional law classes in this country, you would agree that, of course, this is the worst thing. I'm a bit of an outlier. In fact, I gave you a reading from David Bernstein. He was my ConLaw professor, which explains why I'm so messed up. He really does. But the case here is, why did this case come to be seen as the wrong way of interpreting the Constitution? So let me give you a little bit of a background about this case. This is Joseph Lochner. He was an immigrant baker in Utica, New York. That's in upstate New York. Here are photographs of his bakery. There's a cover of David's book. This is Justice Rufus Peckham knocking out Justice Holmes. I told him not to use this cover, but he didn't listen. I actually discovered this print. If you ever come to my office, you'll see it's hanging on my wall. This is a advertisement for the bakery. There were no phone books. There were no phones back then. It was the equivalent of a phone book with addresses. And it says, Lochner's is one of the oldest and most reliable bakeries in New York. And you can see a little picture. It says Lochner's Home Bakery. This thing's still hanging on my wall. At the turn of the century, a common profession for immigrants was baking. And the reason why is it wasn't very complicated. All you needed was some flour, yeast, and an oven, right? You didn't need expensive machinery to bake bread and cakes and the like. So a lot of immigrant bakers would start up bakeries. And one of the attributes of a bakery is you have an oven. And ovens are very heavy. And makes sense. You can't put a heavy oven on a first or second floor. It will fall through the floor. So very often these bakeries were in the basements, right, of buildings, because the basement floor is sturdy. Lochner's bakery was actually on the first floor. If you think about baking, there's a lot of downtime, right? Right? You make the dough, you have to let it rise for a few hours, right? Then you have to knead it a bit, let it rise for a few hours. Put it in the oven, it's got to bake for a few hours, you have to let it cool, right? So there's a lot of intense work, and then you kind of have to wait around for the bread to rise or bake. For most immigrant bakers at the time, this was a 24-hour-a-day job. In other words, they would be at the bake shop all day, and they would take a nap or whatever. They'd rest between the things rising. Unsurprisingly, then, as now, immigrants tend to work more hours. They have to keep their families fed. This was an attribute that is always going to be the case. But not everyone was so happy with these immigrant bakers back in the day. For a lot of the more established bakers, this was competition, right? Very often the immigrant bakers could undersell the big bakers. They could just charge a lower price because they would be willing to get by with a little bit less. So what happened in this case is that New York enacted the Bake Shop Act. Okay? The Bake Shop Act imposed a number of restrictions on bakeries. Now today, maybe if you ever worked in a bakery or a restaurant, almost every aspect of your life is governed by health inspections, right? Almost everything you do, the hairnet, the gloves, the sanitation, there are a 1,000,001 rules for you to think about. But back in the 1890s and 1900s, there weren't these rules. They didn't really exist. This was new. And the Bake Shop Act imposed a number of requirements on bakeries. This law was motivated by competing concerns, right? There were different reasons why this law was enacted. Some of these laws were enacted because they were generally concerned with the health and safety of the bakers, right? The idea is if you have better sanitation conditions, the bread will be cleaner. And that perhaps if the workers have more rest, they won't be so tired, they'll be less likely to make a mistake, right? They'll be less likely to drop a piece of bread on the floor. It's like, look, 5-second rule, pick it back up and put it, for sale. But there were other interests that were motivating this law, and that is what you might call protectionism. That some of the bigger bakers wanted to make it harder for these smaller bakers to compete. You might think that corporations hate regulations. Not exactly true. Big businesses love regulations that they can absorb and their competitors can't. Right? If you're a big company, You can pay to hire lawyers, compliance officers to figure this stuff out, and small business will just shut down. So this law is motivated by different wings. There's a phrase which you may have studied in economics: the Baptists and the bootleggers. Anyone ever studied this before? Right. So during Prohibition, right? Who loved Prohibition? You had the Baptists, right? They liked Prohibition because it made their products more valuable, right? I'm sorry, the Baptists liked Prohibition because it's about morality, right? If you have Prohibition, it will be moral people, there'll be less sin. So you have the Baptists. They're motivated by good. Who else loved Prohibition? The bootleggers, right? Why the bootleggers love Prohibition? Jacked up the price of their gin, right? They're making gin in their speakeasies and their bathtubs, and they can sell it for twice as much. So you often have this coalition, right, where unlikely friends come together. We have the Baptists and the bootleggers both lobby to keep Prohibition. If you don't believe me, are any of you from a dry county? Is there a liquor store on the county line?
Every road that goes out of the county has a liquor store.
Thank you. Now, do you know why your county's still dry?
I have no doubt, because we have one of the largest Baptist churches in the area.
And
the county commissioner is the preacher at the Baptist church.
Who else do you think supports it? God, you make my point beautifully. And who else do you think likes that law being in place, Clint?
I have the Jones family, who owns all the liquor
Thank
stores.
you, there it is, right. So literally, you have the Baptists and the bootleggers. I've never had this before. It actually happened perfectly, yeah. Thank you, Clint. So I think he's exactly right, all right? So very often with public interest laws, you have various coalitions. People with good motivations, the Baptists, and people with the protectionist motivations, the bootleggers. This law is no different, right? Aspects of this law, for example, Section 111, concerns draining and ventilation. Okay, it's a good idea if you have a basement bakery, there's ventilation. I think it's a good idea, right? You need to have the ceilings have to be 8 foot in height. You can't have animals running around. Okay, that makes sense, right? If you're going to be baking bread, you shouldn't have cats are allowed. You can't have other animals, right? You have Section 113. You have to have proper washrooms. You can't sleep in the break room. This one's actually a little bit tougher because a lot of these immigrants could only sleep on the floor while the bread was rising. So this was closer call, but you're getting a sanitation reason why you don't want people sleeping on the ovens. Whatever. Section 114, inspections. Okay, who can complain about inspections, right? And Section 115, the various notices about changes. So there are 6 provisions of this bill, and I mentioned 5 of them. At least 5 of these are, I think at least, about health and safety, right? The court upheld these 5. And most ConLaw books don't mention that part. They say, oh, the court struck and everything. No, they upheld 5 out of the 6. The only provision that was different was Section 110. Section 110 said that bakers could not work more than 60 hours a week, or 10 hours in a given day. And if you were an employer and you employed a baker for more than 60 hours a week, you were subject to a fine. And by the way, if you didn't pay that fine, you go to jail. Lochner never went to jail. I've been trying to figure this out. I know he didn't. I don't know if he paid the fine or the appeal. I can't figure, but he did not go to jail. At least that much I know. So, oh yeah, Gabriel.
I was just gonna say, when I was reading this on Section 112, it says no domestic animals except cats.
Yeah. Yeah, it's funny. I guess cats are clean. They also cats kill mice, so cats kill rodents, so they're actually quite useful in the kitchen. I think that's probably the reason why they made that exception. Yeah. So the law itself made it a crime to employ someone. Now again, this wasn't like forcing someone to work, right? No one was required to work 60 hours a week. So here you had another test case. You had Joseph Lochner, who was the owner of the shop, and you had a guy named Amon Schmitter, who was the employee. And they basically conspired to work deliberately more than 60 hours a week so that they would be fined and they could challenge this in court, right? Lochner was trying to challenge this law because he thought it was a violation of his liberty interest. And what precisely is a liberty interest? The ability to make a contract between him and Schmitter. Schmitter wanted to work, say, 65 hours a week. Lochner said, okay, I'll take your labor for these wages. I want to do this. So the first part of the opinion I want you to stress is Lochner did not make up the idea of a right to contract. That's often people explain that it's simply not the case. You have Civil Rights Acts going back decades recognizing the importance of contracts. You have lots of cases from the 1870s and 80s about liberty of contract. So Lochner didn't make up the doctrine. What is new, though, is how Lochner was very, I would say, aggressive in challenging the justifications of the state. Because the state of New York advanced certain reasons why this law was in effect, this our law, but the court was not persuaded by it. Who's next? Whit. Can you walk me through the court's opinion, please? A majority opinion by Justice Peckham. And here's a picture of Justice Peckham again knocking out Justice Holmes. I told him not to use this cover, but you can even see in the background Peckham, right? And the Holmes banner is like falling apart. And there's Joseph Lochner with the Baker coat on. I told him not to use this one, but whatever. Go ahead.
So he goes through and after establishing the different provisions, focuses again on the hour limit and talks about how the right to contract is an inherent liberty of an individual protected by the 14th Amendment, and that there are certain times when the government can infringe on this, but it is limited to the health, safety, general public moral, and welfare. But then this kind of confused me. He said that it wasn't close enough to, like the hour provision wasn't close enough or closely related enough to be within the scope of that protection. It was too much of an infringement on that liberty. And I guess that's kind of going back to the arbitrariness that we were talking about, but I didn't think it was arbitrary. I mean, to me, working long hours, you could make more mistakes. I mean, it did have a direct relation to a health standard. And if you're going to say that about the rest of them, then it would seem like you would say it also about the maximum hour provision.
Okay, very good. You give lots of good points. Let me try to break it down one at a time. So the first issue is this. The state has a police power. The state has a police power. The state can regulate the public safety, health, morals, and welfare of the people. So again, the court doesn't strike down the laws about the domestic animals, right? They don't invalidate the laws about, you know, ventilation and plumbing and the like. But they say that this regime, the hours law, goes beyond the police power, right? I think Witt framed the issue well. They say it doesn't directly regulate the health or safety of the bread. That is, working more hours will not make the bread less healthy. And so Witt says, that's not true. I mean, how many of you guys, when you were doing an all-nighter in college or whatever, left a few typos in your papers, right? Or if you're scrambling on some sleep deprivation to put a brief in, maybe made a few mistakes. It's inevitable, right? When you're short on hours, you're not going to be as attentive to details. Maybe you'll drop the bread and you'll put some hair in there, whatever it happens to be. But Witt uses this word about direct, right? And that might be one good way of thinking about it. That regulating the hours perhaps indirectly affects the safety of the bread, but not directly. And that's too far attenuated, right? In other words, you think of what they're trying to do. They want healthy bread, good bread, clean bread. What are they doing to get there? Okay. They can require no animals. Okay, directly, that will keep the bread healthy. They say you have to have ventilation and whatever. Okay, good. They'll say you need to have proper facilities, inspections, fine. But having an hour law only indirectly affects the safety of the bread. Maybe the guy's working 10 hours a day here and 10 hours a day there, and he's sleep deprived anyway, right? The fit between the law and the goal is not very tight, right? That if your goal is clean bread, do something more focused, more narrowly tailored to get there, right? If you want to have safe bread, regulate the safety of the facilities. Don't regulate the worker. Why? The worker can decide for himself how much he wants to work. And the deprivation of his liberty interest is far too great to justify this. That is, the mere chance that him working less will make the bread healthier is not adequate. But who's making this call? It's the court. It's a court deciding this law is not fair and it's not just. The court is second-guessing the legislature, right? The court's saying, you know what, New York, you pass this law, this is not adequate, right? And why is this important, right? Why is this important? Because if it's the court intervening, the democratic process has to shut down. Because the people can't enact this sort of law to protect workers from being worked too hard, right? So the police power here, the court says, does not go far enough. And indeed, the court suggests that there might be another reason why this was enacted, right? That this was not enacted about making people healthier. This was not enacted as a public health law. The simple reason of this law is to regulate the hours between the master and the employee. And they even suggest there might be other motivations for this law. And when they say the other motivations, what do they mean? They're trying to help the big baker and shut down the competition. The court was very much aware of the dynamics of this law. He says, Justice Peckham, quote, this is towards the end of his opinion, "It is impossible for us to shut our eyes to the fact that many of the laws of this character are passed from other motives. We are justified in saying so when it is apparent that the public health and welfare bears but the most remote relation to the law." What's he saying? If they're actually trying to promote health and safety, this law is too loose, right? It's too attenuated. It doesn't have a close fit. It's not a direct relationship. This, he says, is basically a special interest law that's not actually designed to protect health and safety. The first 5 provisions are fine, but this last one doesn't work. So you can see why this opinion became so controversial. Not right away, but years later. In fact, Teddy Roosevelt was very much responsible for making this case unpopular. Because during this era, the so-called progressive era, where the government tried to use state power to improve worker conditions and health conditions and the like, the courts were saying, no, you can't do this, right? It's got to be frustrating. Imagine if you're a member of a legislature and you work really hard to pass a law, and you have hearings and meetings, and you have debates and negotiations, and the governor signs it. And then 5 minutes later, the court says, nah, just kidding. You can't do that. That'd be frustrating, right? That applies for any law you enact. But here, the majority struck it down. The majority opinion is generally reviewed today as a way of how not to consider the constitutionality of laws, although I would suggest again, here they upheld the ceiling height law, and in other cases they strike down laws about width of hallways. So we haven't gone much far from Lochner in certain contexts.
So this case is an anti-canon
if you ask most people, not me, yeah.
Because it's struck down, in the wrong.
Yeah, and this case will make more sense when we do Atkins later. But this case came to represent how not to deal with progressive politics. So the same way you had the Commerce Clause, right? Before 1936, the court was very skeptical of federal power. And then after 36, the court became deferential to federal power. Lochner was in the same trajectory. It was a pre-1936 case, but under the Due Process Clause and not the Federal Commerce Clause. Yeah, we teach these doctrines separately, right? We do first federal power and then state power, but the time period was the same. This era in the 1910s, 20s, 30s is often called the Lochner era. I don't like this phrase, but it's often used to describe when courts were skeptical of state and federal progressive laws under both the Commerce Clause and the Due Process Clause. Kevin?
So, I guess does the idea of congruence and proportionality that we talked about in Worley also apply to state legislatures when they pass laws as well?
the congruence and proportionality is what we would call scrutiny, right? The means and fit. And Justice Peckham is doing exactly that. We'll do more on scrutiny later, but yes, it's related. All right, other questions on Peckham? Yeah, Kenny?
Why don't you like the Lochner?
Because it conflates different clauses of the Constitution, right? Lochner was about the Due Process Clause. The Commerce Clause cases were about federal power. So while the Lochner cases were somewhat novel in that only in the 1860s you had this expanding notion of what liberty was, the Commerce Clause cases go back to before the Civil War, and there's a long-standing tradition of reading the Commerce Clause in a certain fashion. So shoving Lochner in cases like, Champion versus Ames, these other cases together, just doesn't fit well. Yeah, Raquel?
So I'm still kind of confused with why the rule in this case was so controversial. Because don't we want to protect individuals' right to contract to do certain things, or is it because it infringed on the state's legislation?
Well, there are two interests, right? Think of the wolf and the shepherd, right? And the wolf and the sheep. Some will say, well, look, the state has to protect workers from exploitation. And then Lochner says, wait a minute, we have to protect our workers' rights to contract. Are they both liberty interests? Depends how you define liberty, right? Are you looking at yourself as a sheep who is being protected from the wolf? Or are you looking at the wolf who wants to have a meal, right? This case only became controversial later in part of the reaction to the New Deal, right? Of saying that we should not have courts second-guessing federal and state legislation. So it fit a narrative more than reality. But when it was decided at the time, it wasn't that big of a deal. There were lots of cases that struck down state and federal laws. Thank you for the question. It's a very good question. But most, this class, I admit, is somewhat anomalous because I've been corrupted by David Bernstein. But for decades, most students were just taught this case is just as bad as Korematsu and Dred Scott. That's the way it is. I've never been able to look stuff like that. Let's do the, wait, no, we'll do the Harlan opinion, yeah.
I just didn't know if there was ever an example of Congress trying to regulate these hours by the Commerce.
Well, we have Atkins, isn't that? Atkins is a federal law regulating wages, so it's not hours, but wages. And that was brought under the Fifth Amendment's Due Process Clause, right? All right, let's do, who's next? Janelli, I can see little parentheses now. Janelli. Give me Harlan's dissenting opinion. Again, Harlan is a 5-4 decision. Harlan was joined by Justices White and Day. There's another dissenting opinion by Justice Holmes. He was alone. No one else joined his opinion. So, Janelli, give me Harlan's dissent, please.
So he believed that the 14th Amendment did have that liberty of contract, but he felt that it still belonged to the states and that the court was interfering too much in this decision.
Okay, very good. So Harlan's opinion, this is the opinion that I'm usually closest to, as you agree with, says this right of contract exists, right? The 14th Amendment protects a right of contract. But this law is within the state's police power. Why? Because it has an effect on health and safety. And he cites all these statistics and all these surveys which suggest that there is a danger of having someone work too many hours in a bakery. Has anyone ever worked in a bakery? Or is it pretty hard to work in there? Yeah. It's what?
When it's brush time,
Yeah. Because it's hot and there's powder in the air, yeah? So Harlan's like, look, this is not like coal mining, right? A couple years before, the court actually said you can have an hours law for coal miners because coal miners is dangerous. But Harlan says, look, this might not be coal mining, but still dangerous work. There are ovens, it's hot. If you fall, you can burn yourself, right? He surveys various working time in different countries. He references lawyers that, lawyers work a lot of hours. Right? I always chuckle at that line. You guys, a 10-hour workday is a piece of cake. If you have that one day, you'll be blessed. You'll have much more than that. But he says that there are lots of reasons why a state could decide that 10 hours a day is enough. Harlan also says that he won't assume that New York acted in bad faith. This is the Baptist and bootlegger questions. He says, look, this is not a mere sham, that it's not the role of the courts to second guess the wisdom of legislation. Courts can decide fairly narrowly. So, let me explain it this way, Harlan's opinion. The majority was very skeptical of the government's evidence. Harlan was more deferential to the government's evidence. Who's right and who's wrong? Right? Does the Constitution say what the burden is? What do I mean by burden? Right? First, is it the government's job to explain why they need this law? Or is it Lochner's job to explain why this law is no good? Say it again. Who has the burden of proof in this case? Is it the government's burden to demonstrate why this law is necessary for public health? Or is it Lochner's job to prove this law is irrational? Now let me twist this a little bit. I've been thinking about this recently. In a criminal case, who usually has the burden? The state. Yeah, I came up with this a couple weeks ago. I was giving a lecture, and this always bothered me. But in a criminal case, the burden's on the state to justify every element of the offense. You guys learned this in first year criminal law. So I think in criminal cases, there's an even greater burden on the government, but they don't go down that road. The majority puts the burden on the government. The majority says the government, right? The majority says the government has the burden to demonstrate why this law is necessary. And the majority says they don't meet that burden, right? They don't give us enough evidence. The Harlan dissent says, no. The burden's not on the government here, right? The burden's on Joseph Lochner to demonstrate why this law is unnecessary. Let me tell you something, guys. When you're litigating in a couple years, if you have the burden of proof, you're probably going to lose, right? If you have the burden, you're probably going to lose because you can't satisfy all the various ways that a court can make up questions. Well, you thought of this, but you didn't think of this, and you think of this, so you lose. So the big difference between the majority and the Harlan dissent is what we call the burdens, right? In the majority, the burden's on the state, and the dissent, the burden's on Lochner. My colleague, Randy Barnett, who was with me in this book, framed it a little bit differently, right? He described it in this fashion. He said that there are presumptions, right? The majority is what might be called a presumption of liberty, right? That the court presumes the right of Joseph Lochner prevails. That this liberty interest, you presume it trumps unless the government comes forward with adequate evidence to disprove it, right? And the Harlan dissent is what might be called a presumption of constitutionality. That is, you presume the law is constitutional unless the challenger comes forward with adequate evidence. Okay? 1 second, Trey. So, under the presumption of liberty, the burden is on the state. And with this presumption of constitutionality, the burden is on the individual, as Lochner. Okay? Why is this important? Depending what your starting point is, you know what your finishing point is. If you're putting the burden on Joseph Lochner, guess what? He's not going to win. The state will win. But if you put the burden on the majority, on the state of New York, guess what? The government's going to lose. Now, my colleague Randy says the Constitution requires a presumption of liberty. I'm with him most of the way on that one. You don't have to accept that. But the choice of which burden, which presumption to adopt will 9 times out of 10 give you the result in a given case. Trey.
Does the presumption of constitutionality have anything to do along the idea of saving construction?
Yes, and I'll give you a little bit better. Do we do Caroline's products yet? Do we do it yet? Okay, fine. I'll do it later. But Trey mentioned saving constructions, right? What is that? Courts have an obligation to find ways of saving a law before invalidating it. So even if the plaintiffs come forward with like awesome evidence that Obamacare is unconstitutional, well, we have a way of saving it, so we'll save it, right? The presumption of constitutionality is Obamacare decision. I mean, that is John Roberts's, if you took like, a blood sample from it, it would look like presumption of constitutionality. That's like in his DNA. He has like a Holmes gene somewhere in his DNA. It's awful. But that 3 generations of Holmes is way too much. But these two presumptions, I think, characterize the majority and the dissenting opinion between Marshall and Harlan. I'm sorry, between Peckham and Harlan. And notice I haven't got to Holmes yet. Holmes is a different story altogether. We'll get there in a minute. But the Harlan dissent agrees that this right exists, but does not agree on how to apply it, of who has the burden. And Harlan says there's more than enough evidence to support this, and I won't presume that the state acted in bad faith. Okay. So any questions on the Harlan decision? Oh, yes, sir, Brian. Such a good question. See, you know the answer. You know we're headed. Yes. What became known as rational basis review, which we'll discuss, I think, next class, traced its roots to the Harlan opinion. Now, what became rational basis review after the 1960s is from Holmes, right? So the Harlan rational basis review was the standard up until about the 1960s or so. But after the 1960s, they went to Holmes. We'll get to Holmes in a minute, but you're exactly right. All right, let's do Holmes. Raquel, did I call on you? So Raquel, Justice Holmes' dissent was really short, but this is probably one of the most famous dissents of all time. What is Holmes getting at here? What's he saying? Okay, very good. The court here, Justice Holmes, begins in a very famous line. He says, "This case is decided upon an economic theory which a large part of the country does not entertain." People often say, oh, he was talking about social Darwinism. No, that's not what he was talking about. He wasn't. He was talking about laissez-faire capitalism. Laissez-faire is a French word which basically means hands off, right? It's a notion that the state should not intervene in economic matters. Holmes says, first off, there's no such thing as a right of contract protected by the 14th Amendment. He disagrees with Harlan, right? He says, there are lots of laws that regulate life, right? There are laws saying you have to close your business on Sundays. There are laws governing the use of mails. There's mandatory schooling, right? He writes, he was a great writer, though. I mean, I can't stand him, but he was a wonderful writer. He says, the liberty of the citizen to do as he likes, so long as he does not interfere with the liberty of others to do the same, which has been the shibboleth, which means like BS, right? Which has been the shibboleth for some well-known writers. And then he gives this famous line. He was a beautiful writer. He had the prose. He was a remarkable guy, though. I make fun of him a lot, but he was actually in the Civil War. He was wounded twice in battle. He was shot once. He went back to battle. He was shot again. Then he hung it up, right? But he survived 2 woundings by gunfire at the Civil War. What's remarkable is I think he left in 63. I checked him out the year. Had he stayed in the Army, he would have died for sure. Basically, at that point, everyone just got wiped out as infantry in his division. So the fact that he was wounded and actually left the battlefield probably saved his life. He was a remarkable guy. He lived to be 90-something, 92, 93. Served in the court until almost he died. But then he wrote this famous line. He says, I'll talk about Holmes more next week, I promise. The 14th Amendment does not enact Mr. Herbert Spencer, Social Statics. Who the hell is Herbert Spencer? He was a famous economist and social thinker who was often associated with social Darwinism as survival of the fittest in society. But here they were talking about laissez-faire capitalism. It was not about social Darwinism. Okay? Then Holmes says that the 14th Amendment was made for people of different views. So you have, perhaps in New York they want to regulate health and safety conditions, and in Texas they don't. But it's not for the courts to decide what is the dominant opinion. Once Holmes said, it's a very famous quote, "If my fellow citizens want to go to hell, I will help them get there. It's my job." So Holmes probably didn't like the New York law, thought he was a bad policy, but he says it's not my job to intervene. Men whom I certainly could not pronounce unreasonable would uphold it as a general regulation. If I voted for it, for Holmes, that's enough. In other words, the only process that's required is a vote by the legislature. Very famous dissent, and the Holmes dissent would be adopted by the courts many years later. So again, very famous decision, reviled in most quarters, not this classroom, but it can't be seen as a thing not to do. You can revile, you can hate it, I don't care, that doesn't really matter to me. But I can never accept that it's the same level as Korematsu or Dred Scott. That one I will not buy. That one is really hard. I think that actually diminishes Korematsu and Dred Scott more than it elevates Lochner. So I think that's the reason why I won't go that far. But
I'm missing something. Why is it reviled so heavily?
this was Raquel's question a couple minutes ago. No, it's quite all right. It's a reasonable question. It came to be viewed as how courts should not stop the New Deal and progressive legislation. It became like this, almost like a talking point, if you will, that we can't have Lochner because then FDR can't get his policies in order, right? It became bigger than it was. The opinion itself wasn't that bad, but what it came to represent is a conservative judiciary stopping a progressive state from enacting their laws. That's the simple answer, Clint. But I have difficulty, putting this in the same level as Dred Scott or Korematsu. I will not go with, but you can say it was wrong. I think the majority was wrong. I think the Harlan opinion probably gets it better, that there were probably enough health and safety rationales of why working 60 hours a week makes you sloppy, whatever. I think I can go that far, that's fine. But the Holmes opinion, though, is very much inconsistent with how contract was understood. Yeah, Cameron.
There's two things I was wondering. One, if he's presuming that he makes himself a laissez-faire capitalism, then why would they have accepted the other 5 articles, which are regulations on their own?
Yeah. So everyone heard Cameron's question, right? If this is about laissez-faire capitalism, why did the court strike out all 6 of the provisions? And this is why most case books don't put all 6 of them in there. It serves a narrative. It was a complicated case. And they said most of these laws are fine, but this one provision, which is only indirectly related to health and safety, is not. That was the majority.
And the second thing I was wondering, what exactly would a law take for him to then say that they have the right to strike it down?
What a good question.
Slavery was the dominant opinion.
So his question is, what would Holmes strike down? The answer is basically nothing. You'll read a case next week called Buck v. Bell, or maybe is that Thursday? I don't remember. This is a case involving forced sterilization, and Holmes upheld it. In the next case, Buchanan versus Warley, in your book I put in his draft dissent. He eventually withdrew it, but he was okay with racial segregation. Holmes said, if my fellow people want to go to hell, I will help them get there. He meant it. He basically meant it. Right? He relished in that people want to screw themselves. Let them do it. So the problem with the Holmes opinion is he would probably pull the lottery. Right? The question I asked you at the first minute of class. Holmes would have said, absolutely, this is fair. Stoner. He was like, yeah, she had it coming, right? Harvest. He used for fertilizer. I don't know. He
So did you say Holmes and Tawney are from the same school of thought?
Holmes and Tawney from the same school of thought? Well, that's a good question. I think they're actually quite opposites, right? Holmes was willing to, Holmes was willing to, Tawney was willing to recognize a property interest in slavery that has used the judiciary in an aggressive fashion. Holmes saying it's not for us, let the people decide for themselves. So I think they're exact opposites. I think this is another reason why people hate Lochner so much. They say that Lochner and Dred Scott are both substantive due process, therefore they're equally evil, right? Tawney recognized a property right to own slaves. Peckham recognized a property right for contract. They're just as bad. Yeah, you think you can have one, not the other. The other reason why people hate Lochner on the right is that it serves as a basis for abortion, right? The same sort of liberty interest at issue in Lochner allowed for a liberty right to abortion, right? Everyone see that? Everyone with me? Okay. All right. I'm happy with this one now. Okay, very good. All right. Any other questions on Lochner? I think you guys get the general gist. Yeah, yes, sir.
Can you tell me a little bit, can you bridge the gap between Harlan and Chicago?
Well, such a good question. So how can you bridge the gap between Harlan's opinion of the Chicago-Burlington Railroad and Lochner? So let me ask you this question. What was Harlan's bottom line in the Chicago case? Was it $1 reasonable? Was it $1 just compensation? In both cases, he ultimately deferred. In both cases, he recognized the 14th Amendment protects his right, but he deferred to the state. In both decisions. Very good point. See that? Does that bridge your gap? Very good. All right, let's do the next case, Buchanan versus Warley. Again, this is a book that, this is a case that's not in most ConLaw case books, but it's very important. And this case represents something of a paradox, right? You had Plessy, right? You had civil rights cases. You had all these decisions reading the 14th Amendment as basically saying nothing at all about race. But then you got Buchanan v. Warley. You have Buchanan v. Warley. And then what does that mean, right? Where a property right was at issue, the court unanimously protected against segregation. This is, again, how I see yick woe. I don't know if I'm right, but when you had a guy being denied a license for his business, then the court intervened unanimously. When you have a guy not being able to sell his property, then the court intervenes unanimously. When you got a guy who can't enter a train car because of skin color, 8-1 the other way. All right, so Ruth, you want to give me the facts using Buchanan?
Yes, so this occurred in Louisville, Kentucky.
Yeah, I used to live in Louisville. It's a good town.
A city ordinance was passed that didn't allow for any colored person to move into a neighborhood that had a majority of opposite colored people.
Good.
And Charles McClellan was right from there. He brought about this case because he wanted to build property to live in the neighborhood.
Mm-hmm. Very good, very good. Okay, so here we have Buchanan versus Worley, okay? Right, we have Buchanan versus Worley. You have a racial segregation ordinance, but it operates in a very strange fashion, right? This is not saying if you're in a train car, you have a car for black customers and a car for white customers. What it's saying is, if you have a block, right, a city block that's predominantly African American homeowners, a white person can't live there. And if you have a block that's predominantly white homeowners, a black person can't live there. Exceptions for servants, if you notice, that was in the statute, right? They didn't want to be too crazy. Right? So here you have a strange case. You have a white plaintiff trying to buy a home on a predominantly black neighborhood. This is deliberate, right? This wasn't a black plaintiff, it was a white plaintiff. Because the statute worked both ways. Wait a minute, Josh, isn't this just separate but equal? Right? Isn't this merely an application of Plessy? The difference is that Plessy did not involve a property right. Homer Plessy didn't own the train car. He had no expectation of entering it. In this case, though, what you were telling Mr. Buchanan is that he could not purchase property, and you were telling Mr. Warley he could not sue it. This was a total test case. I think Holmes got very upset by this, right? That the NAACP, by the way, did anyone see the movie Marshall? Excellent. I really liked it. I didn't think I would, but it was very good. Usually court movies I make me angry, but this was a good movie. It made one mistake, only one mistake. They called it the Maryland Supreme Court. It's called the Maryland Court of Appeals. Other than that, solid. Everything else is good. Usually I just make lists, it's bad, but it's a good movie. Go watch it. But the NAACP brought this lawsuit. And they got a client who was a white guy suing to try and buy a house on an African-American block. And the court here unanimously rules that this is an arbitrary deprivation of his property interest. Again, Plessy is still good law here. This does not even touch Plessy. They didn't even mention, right? It's basically like, this is a separate doctrine that doesn't even matter. Then you have Holmes' dissent. And this is, I think, the question I asked a minute ago. Will Holmes uphold anything? The answer basically, probably, yeah. Holmes basically said that the authority of the state and the police power is reasonable. This law was designed to promote racial stability. By the way, why did Louisville enact this law? They said to prevent race riots. That if you have people of mixed color living together, it'll create social discord. So they need to keep everyone separate. This is similar to the Plessy argument. Holmes said that would be a good enough reason for me. So we put this case in the book to show that in some cases, the court actually was progressive on racial equality when it involved property interests. So if you were a civil rights lawyer in the 1920s and teens, you knew how to channel your case to the court to try and get some satisfaction. Okay. So any questions on Buchanan? Move a little bit quicker because we're short on time. But any other questions on Buchanan versus Warley? Very important case. I teach this one in property also. Very important. Yeah, Gabriel.
So I guess in a way the law was predetermined to keep segregation going since they don't sell to if it was white, black.
Yeah. Yeah, exactly. So the issue there is cities could no longer enact laws mandating segregated neighborhoods, but they could accomplish it with segregated schools, right? They accomplish it with segregated train cars and the like. So this decision didn't have too much of an impact on the real world. But good question. Okay, Cameron.
Why did Tyler Buchanan and Warley? They were in the deal together.
I've looked into this. It's not exactly clear to me. I've tried to figure this out. I think what happened was that there was a proposed sale, and the buyer sued the seller because he wouldn't sell it to him or something like that. I think that's the reason, but I'm not positive. It's a weird posture. I agree. This is like, why was it Plessy versus Ferguson if Ferguson was the judge? It's sometimes it doesn't really make sense. All right, let's do the next case. A little bit back in time. Muller against Oregon, 1908. This case was decided only, 3 years after Lochner. So a couple of years ago, the Supreme Court held what's called a recreation, where they argue an old case. And one of the justices presides, so I went, and it was Justice Ginsburg presiding at Muller versus Oregon. So, and the funniest part of this, and I was bursting at laughing, I'm probably the only one, but she's saying, Counselor, wasn't Lochner versus New York decided 5 years ago, right? don't women have the same rights of contract as do men? Right, and this is the part that students always have difficulty with Lochner and then Muller, 3 years apart, right? How can you rule that Joseph Lochner can't be forced to work 60 hours a week, but then a couple years later in Muller, you uphold a law restricting women's right? Okay? This is like Slaughterhouse to Bradwell, right? Remember that? In Slaughterhouse, the court said that the bakers don't have a right to contract. There's a sense that they do have this right to contract. Then you have Miss Bradwell, it's like, I want to be a lawyer. And the majority is like, well, there's no right for anyone. But then Justice Field said, well, let me tell you, because of the inferiority of the sexes, this is an adequate police power regulation. And I think you have to see Muller in a similar lens that you look at Bradwell v. Illinois, right? In both cases, the court said that the police power as applied to men was not justified. But the police power as applied to women was justified. Okay? The Bradwell opinion, the Muller opinion, is perhaps most famous for what became known as the Brandeis brief. The Brandeis brief. This was a brief submitted by Louis Brandeis, who would become a justice some years later. And the brief was full of all this science. I'm putting science in scare quotes. I'll explain why in a minute. But it was full of all of these journals and reports about why this law was required. He didn't base it on law. There were no legal arguments in this brief. Rather, the brief was all about health and safety. And the brief, you can read it. It's hilarious if you want to read it. Explains why women are physically inferior to men. And there's one line I think I put in the case book. It says that women have more blood in their water. No, damn it. More water in their blood than do men. I don't know what that means. I read this thing. It makes no sense. Another one that he said if women work too hard, their uterus will fall out. No. But so it's basically this stuff that we can sit here and chuckle at. But the court looked at this social science saying, aha, this justifies an additional infringement on the rights of women. And I mentioned the uterus part deliberately because it talks about maternity in here, right? It talks about safeguarding women from things that will make them less fertile and less able to reproduce. And because women are essential to reproduction, this law is justified. So there's this tension between Lochner, which gives the male the right to work as many hours as he well pleases, and then like 2 or 3 years later, you get Muller, which is women do not have that same privilege. And this is why I had the Ginsburg was moody. She's like, so what about women? Right? It was hilarious. I wish they were recorded, but they weren't. So unfortunately, it's only up here. So the court upheld this Oregon law because it's appropriate given the, quote, physical structure of women and the need to protect them even when like legislation is not necessary for men and cannot be sustained. Decades later, the court would rely on the Equal Protection Clause to argue that laws that treat men and women differently need to have an adequate justification. That would come many decades later. Today, and here in Muller, they don't even mention equal protection. I maybe mentioned once, but they don't rely on it. Right? It's all about liberty interests. So, alas, if you were a man, you could work as many hours as you wish, but if you were a lady, the state could regulate your hours. By the way, let me mention this point briefly. You may not think about this. Why were these laws passed limiting women in the workforce? It wasn't out of concern for their uteruses. Let me tell you that much. Utero, I don't even know. For the reproduction. This was protectionism, right? Women were generally being paid less than men, and they could undercut men in the workforce. You used to have Chinese men working laundries. Okay, now you can put women in the laundromat. This was, again, designed to undercut women in the workplace. This is nothing ever changes, right? The next case, Adkins, proves this even more precisely. Why was there a minimum wage for women and not for men? Make it harder to employ women. If a woman works for, say, $1 an hour, make up a number, $1 an hour, and the guy works for 75 cents an hour, I'll hire the guy, right? If the minimum wage is $1 and you hire a guy, I'll hire the guy. These laws were not designed to help women. They weren't. right? I put this cartoon in your book. It's a very nice expression that the minimum wage affirms your right to starve. Okay, that's fine. But as a consequence of these laws, women just weren't employed, or weren't employable, I should say. So it's not exactly as you think. But anyway, Gabriel?
Yeah, I think there's a line that he says, history discloses the fact that women has always independent.
Yeah, exactly. Kevin?
So when Justice Brewer's talking about how long hours, working conditions are dangerous for women, and that's why they can't, that's why they have to be restricted to 10 hours a day. Is that the same rationale, I guess they're saying, for men in a mine shaft, they have to be restricted?
Yeah, it's a different, their physical structures make them have different circumstances.
So I guess a man working in a mine is the equivalent of like stress for like women working more than 10 hours a day, where it has to be restricted. Yeah,
exactly. All right, I only have a minute left. Brian, let me take your question after class. Yeah, I only have a minute left. So the last case, I always put too much into this class. The last case is called Atkins. And this is 1923. At this point, the court became a bit more conservative than it was beforehand. And you have this tension. In Muller versus Oregon, the court upheld a maximum hour law for women, right? Muller upheld a maximum hour law. Atkins invalidated a minimum wage law. May I ask Josh, what's the difference between a maximum hour law and a minimum wage law? Aren't they two sides of the same coin? You can either regulate how many hours a person works, or you can regulate what they're being paid. There's not much of an economic difference. The majority opinion here was by Justice Sutherland, who would become one of the thorns in President Roosevelt's side. He was one of the so-called four horsemen who invalidated various aspects of Roosevelt's administration. But Sutherland was also a very big suffragist. He, in fact, introduced the 19th Amendment on the floor of the Senate. And what he basically says here is, because of the improving station of women in our polity, in our republic, we have to look at this case differently than we did years ago. And even if in 1908 a maximum hour law was justified, today in 1923, right, 15 years later, it's no longer justified to have a minimum wage law. Holmes is besides, and I was like, how can this be? Didn't we already decide this in Muller? Right? Are we going back to Lochner, Holmes says? How can it be that the 14th Amendment changes because of the ratification of the 19th Amendment? Does that make any sense? Does our decision no longer have any merit? But Atkins, and I'll finish up with this point, Atkins is best understood as the conservative court starting to become more engaged with these progressive laws. That Lochner and Atkins are on similar wavelengths. That Muller was perhaps an outlier because of women. But the court here was beginning to become a little more aggressive to stop these democratically enacted laws. By the way, Atkins was not a state law. It was versus the Children's Hospital of D.C. It was a federal law governing the District of Columbia. So here the court struck down not a state law under the 14th Amendment's due process clause, but a federal law under the 5th Amendment's due process clause. Is there any difference to the court between the 5th Amendment and the 14th Amendment? No. Okay, any questions? All right, I will see you all on Thursday. Thank you.